Hamınızı salamlayıram. Mən qonaqlarımızdan da üzr istəyərək öz dilimizdə çıxış eləməyi fikirləşirəm. Azərbaycan dilində
I
çıxış
would like to speak the Azerbaijani language. I apologize before my colleagues. I believe that both the Azerbaijani nationals and our guest will understand me well. So, the subject, which is a remedial secession, it has a certain translation in Azerbaijan. It has a special translation, maybe, in Azerbaijan. And our Spanish guest from Spain he said that it was also topical in Kosovo, for example, subject of remedial secession. So, in some parts of the world, it is a protected, supported notion. In some cases, when remedial secession is really necessary in some parts of the world, especially after the 1990s, when the democracy and the human rights have been put together, it has turned into the self-determination principle, and some countries try to use this principle. And in the Nagorno-Karabakh conflict, Armenia has raised the issue of remedial secession many times. So, let's take the international law, the authors, and two preconditions. They come together on two preconditions. So, in order for remedial secession to happen, there should be two preconditions. First, human rights have to be in a position to be mass violated and rudely violated as one precondition to the remedial secession. And it should rise to a point when that people, that ethnic group, has nothing but separate. So there are authors to it, and if we look at the decisions of the different international courts, we can come across with the notion of the remedial secession, for example, from Canada, then Ms. Lizio versus Turkey at the Strasbourg court. The two different judges use this notion of remedial secession. In the Kosovo, judiciary opinion, Judge Yusuf also tried to refer to remedial secession in his opinion. So you can see that this notion of remedial secession is used in some court decisions. And one of the authors in Azerbaijan used remedial secession as Lex Lata, which has been adopted as the positive notion in the international law. I don't want to speak about this norm, whether this is a norm in the international law. Is there such an international norm in addition to the self-determination? So if it is possible, then in the end maybe we will touch on this issue also from the point of view of the Nagorno-Karabakh conflict. So let's look. Let's take any international agreement. There is no such a notion of remedial secession. Why then is this definition supported by international authors? The General Assembly of UN has three resolutions, one of which is from 1970, resolution on the friendship and cooperation between the nations, and then in 1993 there was the resolution adopted at the World the Vienna Conference, and then the third the resolution was adopted in 1995. So all this, the definition of remedial secession can be found in all the three resolutions. So mainly they refer to the resolution of 1970. So where does this topic come from? This resolution has the part of self-determination and equality of rights in Article 7. In Provision 7 of this article. So the author says that such a definition, the use of such a definition, is only possible when there is no respect to the territorial integrity, or there is racial violence and so on. But argumento contrario, let's take this. Some international lawyers have said that if a nation, a people within a country, its rights are not observed, if there is discrimination towards these people, if they are facing genocide, then we can, extract the meaning of medial secession from these sentences. So if they do not exist, there is no human rights, there is genocide and so on, then a violation of territorial integrity is possible. So such a extract can be made from this declaration. For example, Article 31 in the Declaration on Human Rights, this is a descriptive article which runs that articles and provisions of the international agreement can be interpreted only from within the objective reasons. And in the international community, with the purpose of supporting peace and stability, we can describe this a little bit. Yes, you cannot extract such a meaning from the grammatical interpretation, because in the sentence we see there could be the action only based on the territorial integrity, like there is no condition for the territorial integrity to be violated. So grammatically we cannot extract this meaning, the meaning of remedial secession, as an international norm, as if it is an international norm. We cannot extract this meaning. And most of the international authors have said the territorial integrity is a very ancient international norm. If there was an idea to change it, in 1970 declaration, there had not been just a strict sentence confirming the territorial integrity principle. There would have been, but there would have been no such a reference to the territorial integrity. So let's look at the second meaning of it. The goals of this article within the objective context. In the preamble of the 1970 declaration, it runs, the main goal of this preamble is to ensure international peace and stability in the framework of the UN Charter, as it is stipulated in the UN Charter. So the peace and stability are shown both in the preamble of the declaration and in the UN Charter. So then, if we interpret the declaration from this point of view, and if remedial secession can create peace and stability challenges to the countries, because the remedial secession has a lot of gaps. So the gaps which can be filled in arbitrarily by different peoples, if it will let the ethnic groups to fill in those gaps in the remedial secession, then we will be in a position to stimulate actually those ethnic groups, declaring to them that you have such a right for remedial secession. And what will happen then? And it has been has been referenced also in one of the his author's reports. So a state, the majority of this state becomes the nation to blame for such issues. I haven't said that. The American also said. But if we look at from the bird eye, the ethnic group which wants to be separated, is assessed, turns into a struggle with the majority nation within a country to that extent that human rights become a problem. Ader, the American author, what he said can be also seen in the Nagorno-Karabakh, in NK, I will call it NK. So, if Vartanos Karen said that the Armenians had no other way out to just to separate in NK, but from the other side, in NK, the nation, the people whose human rights were violated, who were subject to looting and had to leave, have to flee this area. So nobody speaks about the human rights of these Azerbaijani Turks. And he's also saying that if we are talking about the remedial secession, so it should be linked all with the democracy. But when we look back at those issues, that the ethnic groups which say that as if they have been residing on the democratic principle, but it turns out that they have not in their actions been guided by the democratic principles and violated the human rights. Theologically, if we describe this in such a way, we can come to the same conclusion. So in the international law, there are many mechanisms to protect human rights. If there are such mechanisms to protect human rights, if these human rights are violated, and then this ethnic group which has violated these human rights will turn into a separate state with that mechanism of protecting the human rights or violating them, does not follow the UN Charter, for example. It showed itself in Libya when human rights were rudely violated. The UN was involved to correct the situation. When we look at this within the framework of the international norms, it is not possible to solve this with some international agreement. We'll look at the practice of the world. Can we extract the remedial secession definition from it that it is not in the international agreement anymore? So I believe that we will discuss this further. If we look back at the practice of the world, of the different states of the world, we can see this. But on the opposite, some countries have not accepted this practice. For example, if we look back in 1945, what happened in Africa. Then starting from 1990, the Yugoslavia and then USSR collapsed, the problems which followed those collapses. We can see that the states do not accept this remedial secession as a norm to confront the violation of human rights. So, for Kosovo, the International Court did not accept this either, and this issue was not included in the General Assembly, UN General Assembly, and declared that they would not accept this. They will look back what the court reviewed, so we will come to the same result. So, in conclusion, remedial secession, if we look at the Article 38 of the court decision, only if there are some conditions, which can be found in some court decisions in the works of some authors, but in the international agreements there is not a notion of a remedial secession used. If we look at the World states practice, they do not accept this remedial succession. Lex lata, if we look at all of this, so it has not been accepted at the international norm on which some ethnic groups or groups can use to go for the remedial succession. So as for the NK, Nagorno-Karabakh, so we should assess this in a different way. If we say that this is an international norm, then this norm has to be assessed within the specific conditions around this norm. And we should not accept it for any action in that direction. We need to look at the human rights, whether they are violated. If they are violated, and to what extent that there was no other option but separate. And then we have to assess this at using the full picture of the situation. Thank you very much for your attention.